testing. There was a motion. We filed a motion to limit Dr. Babcock's testing and opinions
His
based on
testing is different than saying, were they stored in vinegar? That's two different things.
No, it is not.
How the hell is it not? Oh, I'm done. I gotta go take a break, Your Honor. Can we?
You can take a break.
Thank you. When you're gonna lie like this, my goodness.
No, I don't appreciate being called a liar.
Then that's why I need to take a break.
Take a break, Mr. Rasmussen. Right. So.
Ms. Gallagher, Joel Odou for Real Water, we've met before. Thank you for coming today.
Thank you.
Again, very sorry that one got sick, very sorry that Real Water caused it, very sorry that Odou caused it. What were do you remember what your total medical bills for Orion were? I can give you the answer. About $200,000, does that sound about right?
Something like that, if I remember correctly.
Okay. How's he doing today?
He's okay. So far, so good.
Started school yet?
Preschool, yes.
Enjoy it. Wonderful time.
Thank you.
No questions, Your Honor.
Thank you, Ms. Gallagher. No questions. All right.
Nothing further, no.
Okay, ma'am, you were released.
Yeah, just logistically talking.
Adjourn. All right.
So we start. Finish out these two things. And then
All right, it's my understanding that this time the plaintiff's rest, is that correct, Mr. Chairman?
Yes, Your Honor, ladies and gentlemen, jury, Your Honor, plaintiffs formally rest.
Okay. All right, ladies and gentlemen, I think just a couple comments. And this doesn't happen very often, but I think we've heard a total of how many witnesses so far?
29.
29 witnesses. I mean, and so, the lawyers are to be commended for being very, very efficient. I mean, they really and truly are. And we haven't had much downtime, And so anyway, I think what we're going to do right now, and it's after 4 o'clock on Friday, we'll go ahead and break for the evening, right? But I understand we have a holiday on Monday, right? And you know what, ladies and gentlemen, things kind of work out well because there's certain things we're going to resolve during that time period, so you don't have to sit and wait for us to resolve them. And what I mean by that is this: I'm meeting with counsel at 1:15 on Monday to settle jury instructions, right? Remember we talked about the law and how important that was as far as the case is concerned. And we're going to do that in such a way where they'll be settled and resolved, so you won't have to wait for that. And Tuesday morning at what time?
10:30.
10:30, we'll start the defense case. But we're making really good time. We really and truly are as far as cases go. Is there anything else, counsel?
Clear.
All right. So anyway, remember you're admonished not to converse amongst yourselves or with anyone else on any subject connected with this trial, or to read, watch, or listen to the report of a commenter on the trial of any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember the prohibitions? And last but not least, do not form or express any opinion on any subject connected to the trial or the cause that's finally submitted to you at the time of deliberation. And so, Monday morning, 10:30, or different than
Tuesday morning.
I'm sorry, Tuesday. Tuesday at 10:30. I guess I'll be here Monday morning by myself. And so anyway, that's what we'll do. Tuesday, 10:30.
All rise to the departure of the jury.
Enjoy your weekend, have a safe weekend.
Jury is clear. Please see the thank you.
Thank you. I guess that's a wrap for the weekend.
Thank you.
Oh, we have one now?
Yeah, that's correct. Remember, Your Honor, after lunch, there was.
Oh, okay, I understand.
Yeah.
I'm with you.
There was a person there. I observed the jury taking a smoke break right at lunch. They rushed out here and they went to the smoking balcony there on this side. And I went to the bathroom, I came back, and then I saw this woman, I don't know her name, who's been sitting in the back. And I asked the plaintiffs who'd been there waiting for me to go to lunch, I said, well, was that woman with the jury out on the balcony? And they said she was. And just, it had to be at least 4 or 5 minutes, John. I don't know how long she was out there. But that smoking balcony, not as big as, it's like 3/4 as big as the jury box. Right, it's small. So she was within 6 to 8, according to the client, she was within 6 to 8 inches of jurors smoking, and, they couldn't judge whether she was talking to them or not. I don't know if she was, I'm not sure of that. But, when we came back in after the lunch break, I asked the marshal who that was, and he made an inquiry. Theodore Parker actually made the inquiry. And we found out that she's some sort of insurance monitor for one of the Hanna Instruments companies. And as I understand from Mr. Rasmussen, she's some independent person, but she lives under the control of this insurance company. And I don't know how old she is, but she looks like she's at least up to 50. And I would think she understands that the insurance people shouldn't be in that kind of proximity to the jurors. So I think, number one, she shouldn't do that again. And then number two, I was hoping we could voir dire her, and I mentioned that at the bench to see what was going on. And now she's skedaddled, I mean, when I was a little kid, I rented the room to keep from getting spanking too, but she's professional. She should have stayed for this incident. And I don't know what we can do at this point. She's gone. Maybe we can require she appear Monday. We can talk to her then. And what I suggested at the bench is maybe she could make copies of her notes and put them in an envelope so they're good for review if the person turns into something. I'm just concerned that she may be out there trying to read it off on what jurors say and send reports to the insurance company. Looks good, looks bad, jurors are happy, unhappy. You just shouldn't be in that kind of proximity to the jurors. I mean, she sat here over and over again. You told counsel, you told the jury that we can't get close to it. I don't know what she was thinking. That didn't apply to her. And I don't know what her experience level is. She does seem to be an older person. I don't know how long she's been an insurance monitor. But this is not something that should have happened. And I can't say it's prejudice because I don't know. But I can say I'm very concerned about the situation.
All right, thank you, sir.
Your Honor asked me to take care of it. I did talk to her. She had not really spoken to them except for when she walked through the door and said, I need a light for a cigarette. That was the extent of it. I told her never to go near them again. I told her to take breaks on a different floor. I found out her name was Kathleen. That's all I know.
Will she be reappearing?
Nope.
Just now we know she's talking.
She asked for, I think she asked for, when was that, was like, hey, can I get a light as well?
So she's out there on smoke breaks with the jurors, asking them for lights. I mean, that's just beyond the pale.
Okay. You want to ask her to come back? I don't know where she's from. Okay? I didn't hire her.
Well, I understand that, and but nonetheless, even if she's an independent adjuster, which she might be, she's working for some carrier, I would anticipate, either primary or excess or something, right?
Right.
And here's my point. I would recommend that she continue coming to court. And I don't mind saying this because it potentially looks suspicious if she doesn't show up on Tuesday, right? That's kind of how I see that, know, and if she comes in and said, look, I just wanted a smoke break because I have a nicotine habit, okay, but, we'll find out, and I would anticipate hopefully she'll come back.
We bring her in at 10 o'clock, so we'll.
I can't control it. Well, I appreciate that. It's not in my
I
control.
understand that. It's one of these things where I would hope that she would come back.
I gotta go figure out where, I wait and talk to her,
I understand.
okay?
Well, and I did
At
that.
your request.
Well, I did that purposefully
Yes.
because they requested the marshal to talk to her, and I thought that might not be.
You wanted me to do it, and I did it, and I did exactly what you told me to do. Don't ever go near them, don't be around them, don't do anything. I don't think she's as experienced as people think she is. But I don't know. I don't know her.
Now she's on the landing on her, she fled.
Look, I didn't tell her to leave either. I just told her, that,
No one said you did, sir, and I don't want your blood pressure getting going up.
thanks, Will.
We want to keep it down, although you didn't get
I'm not
it.
kidding Mr. Rasmussen.
No, he's not.
But she did skedaddle.
I hope she skedaddles back so we can. Right? We'll deal with that on,
10:30 on Monday, or not 10, 1:15, right?
1:15 on Monday.
Monday.
I would anticipate, in a general sense, the strict products liability and the instructions don't seem too complex and too complicated, right? So maybe
Not to us.
hopefully we
We
can
got
have,
some issues.
yeah, but I mean, we always have issues.
Yeah.
But I mean, it's actually more difficult trying to sort of draw instructions in each contract.
That's true.
Because you don't have model instructions. You always have to be creative with other states and everything. But I'm hoping, well, I know this will get done. As we leave Monday, the jury instructions and verdict forms will be done.
All right.
Part 16 is now in session on Please be seated.
Okay, good afternoon, everyone.
Good afternoon.
All right. And, have we had a meeting confer with Denny on the jury instructions?
No, Your Honor, I think we're fairly close, judging from comments under here.
We're fairly close, Your Honor.
We are most of them.
What do you need help with?
It's probably best to just go through them one by one and,
If Judge, I had two housekeeping matters first. First, that incident we talked about on Friday where the insurance adjuster was smoking with jurors.
Right.
She's not here today. I haven't forgotten about it. I just think we still need to get to the bottom of that. And second, Mr. Parker has prepared to have an associate of his go to attend Jason Brown's end of the deposition or video transmission if we're going to do that. And we just need to know the details of that. So, because after talking to Mr. Odou, I can't see how he's going to go past noon with his three witnesses. And so we might begin with Mr. Brown first thing in the afternoon, I would think.
All right.
Not knowing if Scott's Mr. Rasmussen's gonna call him versus Mr. Robbins. So, Your Honor,
So you want to make sure that someone's there when he's giving his testimony?
bingo.
Right, sure.
And you mentioned it, Your Honor, when we were reading into the record, the guidelines in the Rule 43 and then Part 9.
Right.
It says certain safeguards should be in place. So we have an office in South Carolina. I can have one of my lawyers in South Carolina simply drive up or fly to wherever they are in North Carolina to make sure that everything's being done correctly. I would hate for this person to have access to a monitor or someone else be in the room to help or assist him in his testimony, where otherwise any other witness in front of the jury, in front of the court, would not have that available to them. So
That's a valid concern, Mr. Parker, and that's provided for pursuant to the rules.
absolutely, Your Honor. So Mr. Kemp came up with an idea this weekend that may be even safer for the parties, but it may take a little extra time on the off hours when we're not in court. We could do a preservation type trial testimony deposition, a deposition to Benny with Mr. Brown off the court hours, when the jury's not here. And then that way we can make sure Mr. Brown does not mention anything that's been prevented or precluded based on the motions of limine. Again, we can have my firm from South Carolina participate there, and we could get it done. And Mr. Rasmussen or Mr. Robbins could question them about the issues they want in front of the jury. We just don't want to take a chance of the motions of limine orders being violated, and we want the proper safeguards in place. So either way, we're willing to work with Mr. Robbins and Mr. Rasmussen to facilitate this from happening, Your Honor.
I understand.
I'll respond, Your Honor. If he's called at all, it would be not called by Hanna, it would be called by Milwaukee, so you don't have to worry about it tomorrow. That decision is still being made right now, and I hope to have an answer on it this evening. So,
Well, Judge, I think we do have to worry about it tomorrow, because Mr. Odou gets done by noon. We've got 4.5 hours to fill, and I don't know what Mr. Rasmussen is to call, but I don't think he's got 4.5 hours, so it might be a tomorrow issue.
Scott can speak for himself, but my impression is he has enough to get through the rest of the day.
I think so.
Well, can we have a list of Mr. Rasmussen's?
I think I gave it to you, Teddy, we talked about it on Friday.
We did. You said that it was still up in the air. I can tell you the list. You know how I am about note taking. So I'll tell you, I'll read to you what you gave to me. You said Carl Savaggio, Babcock, Fortenbaugh, Tim Shannon, and Adrian Petrian. You didn't indicate lengths of time. You didn't indicate whether or not it would be depot read-ins.
There will be one depot reading, yes.
I'm sorry, all of them?
No, Teddy. There will be one depot, volume 2 of the deposition of
Who?
Casey Aiken.
Casey Aiken, volume 2. And then what other depot reading?
Tim Shannon.
Have we done designations on those depositions?
Yeah, we did a page line, yeah.
I don't think.
I did a page line, yeah, okay. I didn't see your page line on Shannon.
We did, they may not like it, but we'll try to get that worked out between here and tomorrow.
Or Aiken.
For Aiken. Tim Shannon, I don't know that we have that one done.
Yeah,
It's gonna be-
to be honest, I don't think Shannon really has anything to say. He's not a financial guy that didn't know anything.
So let's just finish up, Mr. Rasmussen, so everyone's on the same page. Is it Carl Savaggio in person or by depot read?
In person.
Okay, in person. Babcock?
In person.
In person. Fortenbaugh?
In person.
All right. And then Adrian Petrian?
Eddie Peterson is not gonna be,
So he's off the list?
yeah, I thought it was, I should Tim Shannon, if I made that mistake, Teddy, I apologize.
No worries. And then, in terms of the order of witnesses, who can we expect on Tuesday after Mr. Odou is done?
I suspect it'll be Carl Savaggio.
Okay,
Then it'll be the read-in of the volume 2 of the Casey Aiken deposition.
okay,
Did you say video?
Sorry.
We don't have a video yet?
We do have video.
okay.
Why should we read it, not video?
I'm sorry, it is the video.
Okay.
Okay. And then,
And maybe I'm just the semantics I'm messing up with, I apologize. What we have been doing so far is the video deposition. There's 2 different depositions that we're taking, Mr. Aiken's, they did volume 1 of Casey Aiken, we intend to do volume 2.
okay.
Is it already gonna be opposed that we can't do it, Eric?
I'm not positive, I'm just.
Well,
Well-
no, we need the paving lines. I think all that was designated for him was like 200 pages or something without any.
We did that, I thought we got it over to you and we'll.
Yeah,
I'll
which state
confirm it out.
and then,
Who's
so,
number 3? Who's number 3, Mr. Rasmussen?
So David Fortenbaugh and then Jason Babcock.
Number 4. And then Tim Shannon is number 5?
Yes,
Okay.
and that will be just a deposition.
what about Petrie?
You can scratch that off.
I'll scratch that out.
Scratch out what you, okay, good.
All right.
I think that'll take us to 5.
Okay, good.
Yeah, that should take us 5.
Good.
Well, that we do all, if we do Savaggio, Fortenbaugh, and
Babcock.
Babcock tomorrow, that should take us to 5. Right.
You got the read-in. But at least we got a list.
And I would like clarification on something, Your Honor, too, now that we're talking about it. So I'm not certain, but it's, I think Mr. Odou is having Mr. Jones fly in for just a short amount of questioning, it sounds like, and then he's flying back out, which is fine. I can use his deposition if that's the case, because I don't know that Scott's gonna call him, but I'm gonna call him at least through his video deposition testimony. So I just want to make sure there's no issues with that, Your Honor.
And I have an issue with that. I have a different issue with Mr. Jones.
Mr. Kemp,
Is he not coming at all?
Mr. Robbins, you're not gonna cross him, you just put his video up?
No, not if, I was told he has very few questions, so I doubt we're even gonna get into those issues, so.
Yeah, I don't have a problem with that. I mean, he has been designated as the management speaking agent, so I think Mr. Robbins has a right to play the video.
I just want to make sure, Your Honor.
While we're talking about Blaine Jones, Your Honor, I talked to Mr. Odou about it, and I understand why he wants to call him, but there's some real problems here, you know. Number one, I don't want him to say anything about the bankruptcy, so I would at least want the court to address that specifically with him, you know, rather than rely on someone else to address that. Number two, I don't want him to say that Real Water is shut down, which, you know, since he's the only one that makes it concentrate, as soon as he says he's got another job, the jury's gonna think it's shut down. Number three, obviously I don't want him to talk about insurance or anything. And then number four, there's this issue about him being a plaintiff and his complaint. You know, hyper-technically, he's not really a plaintiff because the bankruptcy trustee has refused to lift the stay to allow him to pursue the action. He did file a complaint.
Yes.
That was filed. You know, so, I mean, so the meeting.
He was the employee, right?
Yeah, he was the vice president, he was charged to make the law. So
So who did he file a complaint against?
Real Water, Milwaukee and Hanna.
I think he has a distributor?
I can't remember if he has a distributor or not, but I know there's those three leases.
Maybe you're right, probably not the distributor, you're right.
So I mean, you know, if Mr. Robbins isn't gonna do it, then if Mr. Rasmussen starts asking questions about the meter, I think I'm entitled to say, well, you allege that the meter, you know, there's a failure to warn and blah, blah, blah. You know, I don't really wanna go there, but if they start going one way on the meter, I gotta go the other way. And I see that being a real problem, because I don't really think we should inform the jury that he's a plaintiff or he's filed a lawsuit or what the allegations are. But if we're gonna discuss meter with him, we pretty much gotta do that.
Joel, do you have anything on this?
Yeah, just very briefly. I agree with about 95% of what Mr. Kemp said. I think it's problematic as to his lawsuit. I had joined in the motion to eliminate. Mr. Kemp raises an interesting issue, the fact that that lawsuit, the stay has not been lifted for that lawsuit, and that creates an additional issue. I certainly would only ask him about the lawsuit if other parties can ask him, because I want to give the jury a little bit of an inoculation that, you know, it's not a surprise to the jury if other parties are going to ask him. If other parties are not going to ask him, I have no intent to ask him that. I just don't want the jury to hear that first on cross-examination and think I'm trying to hide something. As far as his testimony regarding the meter, basically the only thing that I had planned to ask him to testify to was how to make the concentrate, how to make real water in very, very, very broad terms. In other words, pretty much no different than the flow chart that I think has been admitted evidence by the plaintiffs that shows, you know, step 1, step 2, step 3, only because I think that the jury still may not have a very clear picture of it. You know, I'm going to spend 5 minutes on it at most. It's not a big part of his testimony, but I do agree that the witness will need some guidance from the court on the things that he cannot say. Certainly, we do not want him to talk about insurance. We don't want him to talk about the bankruptcy. We don't want him to talk about Real Water being out of business. We agree all of those subjects he should not talk about.
Yes, sir.
I agree that nothing should be discussed about insurance. I agree nothing should be discussed about him no longer working there. I agree that nothing should be discussed about the business is shut down. Nothing should be in about insurance, bankruptcy, his new job. Those parts I don't have a problem with. That he has filed a lawsuit is a public thing, and his motive for answering questions, I think the jury should be able to know that he's filed a lawsuit with regard to my client. So other than that, I think we're okay, but other than that, when he gave his deposition testimony, he was not a plaintiff in a lawsuit. Since that time, he's become a plaintiff in a lawsuit and named my client. And so I would like that. It's a public document. It's certainly not protected by anything that I'm aware of. It would say, I can't let that in with regard to the fact that he's filed a lawsuit against my client. I think that's a pretty normal question to say, and Mr. Jones, you've actually filed a lawsuit against Hanna Instruments, haven't you? If I want to ask that question. I don't know that I will, but I don't know the prohibition. What are we trying to protect? What's the prejudice versus the probative? So I think it's important that we be allowed to go ahead and ask that question. Other than that, I'm good with this.
How's it relevant?
So what are the claims that you're bringing against my client? What are the claims that you're saying my client did wrong? If I want to go there, I may not. The relevance is you filed a lawsuit against my client. Why?
How is it? I'm just trying to figure out how the lawsuit stands. Who represents him?
Mr. Christiansen,
Yeah, I'm trying to figure out. So he's suing the company that he worked for.
he sued Real Water, he sued Hanna, he sued Milwaukee, and maybe other people in the lawsuit, I'm not positive.
Okay. Interesting.
Yeah, I am.
I had some responses to why
Oh,
it's
yeah,
problematic, but I'll let
Mr. Robbins, sir.
So the issue, Your Honor, we've actually, excuse me, already had a limine motion on this. And so again, that was already argued. And I believe the ruling was there's no mention of who his counsel is or inferring that it was Kemp Jones, which it's not. But the real issue for us when we argued that was bias, okay? They just played a video clip of him the other day saying that he wouldn't take $10 million, right? And was he intending, when he made that statement, was he thinking, geez, I'm gonna sue, I'm gonna be a plaintiff? So, if he changes his testimony from that of his deposition, now that he's a plaintiff, I think it 100% goes to bias. So we absolutely, I don't know that I intend to bring it up, but if his answers get squirrely from his deposition testimony, then I would think the fact that he is attempting, whether he is or not through bankruptcy court, is attempting to be a plaintiff, does go to bias. So that's the issue for me, Your Honor. Like I said, we've already had a ruling on it.
we've already played the video of his injury. And I don't intend to replow that ground other than to inform Mr. Jones that the jury already knows of that. In other words, the jury has heard testimony via video of Blaine Jones describing that liver failure is not something anybody would want to go through. At the time that he gave that deposition, he was not a plaintiff in any case. The reason why it's problematic, and this is...
I can see it being problematic from a lot of different levels, but go ahead.
Yeah, the bankruptcy has stayed, or his case has stayed by order of the bankruptcy court. That stay has not been lifted. If somebody starts to ask him about that, and he says, yeah, I haven't had my day in court, or my case is stayed, or there's no safe answer to that. And that becomes problematic. And the other problematic thing is he's not represented by Kemp Jones. He's not represented by Joel Odou of Wood Smith. He's represented by a completely different attorney. As far as the $10 million statement, that's what he said before he filed the lawsuit. I don't expect him, I'm not going to ask him about it, and I don't expect him to change it.
Interesting.
But it could change. It could double.
He could.
Could say anything.
Yeah, and here's the thing, I mean, I don't mind saying it. Traditionally, I understand the bias argument. But I've never seen a case in a products liability claim where one of the employees who happened to be an officer for the organization sued his own organization. I don't know how that's gonna play out. I mean,
For
I
the
really
same, for
truly
the same thing.
For the same
Exact
thing.
Same thing.
And the first thing that jumped in mind was, I guess, well, of course, it doesn't appear to have application, but I thought about, is there a work comp bar for this? I mean, I just kind of went through it and I can say, well, maybe in that, during the course of scope, hey, I don't know. If he drunk it while he's on the job, I mean, I don't know.
It's Mr. Christiansen's problem.
Yeah. These are just listening to it for a couple of minutes, all these potential issues here. And I mean, traditional bias, I get it. But is it a bias when you sue your own employee for something you manufactured yourself?
He sued me too.
Oh, I understand, I do.
And isn't that also a potential problem for you guys? I mean, do you want them up there saying, yeah, the meter's defective, I see it?
I may not either, but and I'll just address and I'll be square about it. If he sticks, well, it may not be an issue, because if we do the video depot, then he's not gonna change his answers. I don't have to worry about whether bias played an issue and change his answers, because we're just gonna play the depot testimony. So if that's the case, then I would not, there's no issue to even address at that point, and I won't be asking any questions in that regard during it's not gonna come up, so it would be beyond the scope when Mr. Odou puts him on the stand.
I agree with Rob on that. It really depends on when Joel asks, Mr. Odou asks him questions, right? If we know what his deposition says, and if he's off here now, then bias comes into effect. Why are you saying this now? What's changed? Well, you have the ability with a deposition to impeach the witness. That's one of the reasons that you do that. You have those depositions. Hey, you said this here, now you're saying this here. And by the way, aren't you now plaintiff? Haven't you sued my client? You didn't at the time you gave this deposition. Now, I don't want to get into bankruptcy. I've already said that on the record. I will not ask a question with regard to that. Certainly I can't control his answers, but Joel's here to, is he your client still? I don't even know the answer to that question. I assume so.
Mr. Odou, anything?
He's a speaking agent of the company that
Yes,
is
he is.
sued by order of this court, so.
Yeah. And there's no case law that I could find on this issue, by the way. We looked.
I mean, and is it bias or not? I mean, a
He
traditional.
did testify at the time of the deposition that he had consulted with an attorney and he had decided not to sue. That's what he said at the time of the deposition.
That's true.
He changed his mind later, apparently, obviously. But at the time of the deposition, he said he had consulted with an attorney, not Mr. Christiansen, and decided not to file a suit.
Because how do you, I'm still having difficulty with the claims for relief, because, and I mean, I understand traditional bias, and this one is very unique, because what he would be saying is, yeah, the product that I helped make was defective. Right?
So you're admitting
Oh, yeah.
lots of things in the defense part.
Exactly. I mean, it's, I get it, bias, I mean, it's very basic, but it's potentially an admission, right?
Well, they've already.
And there's been a stipulation, they've agreed to accept responsibility, so then it comes down to relevance. I mean, there's a lot going on here, it's layered. But go ahead, Mr. Robbins.
I'll just reiterate, if nothing comes up about org meters on his direct, then I don't have any issue. Because I'm just gonna play his depot.
Exactly.
So.
And I may, Teddy, at that point, I may be the one that offers the evidence. If nothing comes up about the work meters. And we've already done the page line on that, you guys have seen those. No, we haven't now, Eric? We haven't provided you with the
All
plain
you did
Jones?
was, when we did our designations, you guys counted the whole thing. You didn't toss it out.
Well, there's two different volumes there, so.
Do you have it with you now, or can you email it to us?
We will get that done, yes. We'll get it to you tonight.
Okay, very good.
So I guess we have an agreement that unless Joel asks questions of Mr. Jones related to the meter, there will be no cross-examination by Mr. Robbins or Mr. Rasmussen.
And in anticipation of that, then his deposition will be used, and that's gonna be okay.
Yeah, that's okay.
You follow what I just said?
I don't think I can ask many questions myself, Your Honor. There's just too many
Landmines.
landmines out there, right?
So
But
I
if
guess
that door is opened, or he opens that door himself, we'll be prepared to talk to him about it.
We can tell them not to talk about the meter. We can
What?
tell them that.
But yeah, I can tell them ahead of time, I'm not gonna ask them any questions about the meter, and don't talk about the meter now. I would hope you would follow
was he
that.
questioned on the meter during his deposition?
Yes, you are.
Yeah, it's extensively. I mean, the only thing I was gonna have him do is walk through how the water is made. One of those steps is you use a meter. Like, maybe I tell him omit that, but then, you know, we have the problem
Some of the
of.
questions I'll be asking is about the pH, the TDS, how it was done, that sort of stuff.
I think it's riddled with issues. You
What,
start.
I can't help that.
Listen, this is what I would say for the benefit of the plaintiff's position. We got this witness on and off with simply deposition designations. To the extent that a co-defendant brings that witness up, those problems are going to end up being the defendant's issues, not the plaintiff's issues. So they have problems between themselves, Your Honor, and they open the door for problems that they create. The Joel bringing him on as a live witness, that's the only thing they can do is prejudice the plaintiff's position. And so as long as they're aware of that, I don't care what they do to each other. They can stab each other in the back, 10 ways from Sunday. But to the extent they prejudice the plaintiff's position by somehow letting bankruptcy come in, because we didn't bring it in, letting the shutdown of the business come in, because we didn't bring that in, insurance come in, and if for some reason he said something negative about that meter, we shouldn't be prevented then from,
More positive about the meter.
or we should not be precluded from then addressing that issue on cross.
How did he address the issue during his deposition testimony?
Well, Your Honor, you gotta remember, he was deposed
Extensive.
twice. He was deposed all day as a PMK, and then he was deposed for another 2 hours, 3 hours.
Oh, no, longer than that.
It's almost like two full days.
So there's a lot of testimony about the meter in both volumes.
Well, the PMK was mostly just the concentrate making process. Honestly, his testimony is kind of benign on the meter. He didn't remember much, and he didn't really do that aspect of the production at any time recently. I mean, he said what he said. I mean, if they're gonna play his deposition in their cases in chief, I mean, they have all the testimony that he gave on the meter. I mean, I don't know that it's something we need to go into tomorrow.
We can certainly, and I think I'd already included at least part of it, the description of the process that he gave. Joel, just if that helps or doesn't help, I don't know. But and he did talk about the meter, and so we think it's important that it come in. But I'm happy to include portions of the process that he talked about there, because I think I've already included it anyways. That solves anybody's problems, and maybe it doesn't, but.
All right. So, no discussions regarding insurance.
Agreed.
The current status of Real Water as a business entity, right? That's out.
Yeah, agreed.
Yeah, and then the BK filing. Well, Mr. Odou, are you confident that he will be able to follow your guidance and instruction?
Yes, Your Honor, on all of those topics, there are no questions we intend to ask him that would lead to any of those.
So just for the benefit of the court, since the court asked this question, I bring all the deposition testimony with me, Your Honor. And there's in the first deposition, there's over 20 some odd pages dedicated to the meeting. So just this as a snippet, I would suggest that you be very careful, Mr. Odou, because that's just on volume 1. I can pull up volume 2 and let you know how many pages are dedicated to the meter. But he goes back and forth between the 5 minutes versus the vinegar versus calibration.
Right.
So it's replete with issues related to this meter, or at least 20 pages.
And none of those are our issues. We have no claim against the meter companies. They have no claim against us, so.
But that doesn't
I won't
mean
be
that-
asking him about the meter.
I just would warn you, caution you that if
There's no subrogation? I mean, there's
There is
no,
not.
it'd be-
Cross line.
I got you. Okay, so where do we go from here? How are we gonna bottom line this?
So we, again, would request that, right before he gets this on the stand, outside the presence of the court again, to admonish the witness. No discussion on insurance, bankruptcy, or the company being out of business.
Anybody have a problem with that? Just make sure, you make a checklist for me to go over. Just in general, since I know what to ask, can you prepare a list of 4, 5, 6 points that you want me to address with them? And if everyone approves, I'll do it.
I don't know what to do as far as OOP, I don't know what we can admonish him on that.
On the meeting?
Shouldn't come up.
It shouldn't come up, the reality is that his answer to Joel, he has to talk, you know, if I gotta say this, then I don't know what to do with that.
Well, I mean, I think at the end of the day, what it
Yeah, but
really
don't say
focuses
shut
on
down, it's a recall.
Does he have any criticisms regarding the function of the meter? And or instructions?
Yeah.
That's what the
I
revision
didn't highlight
is,
it. I
right?
don't think so.
No, it's exhibit one.
Yeah, that's gonna be.
We may want us to
But I mean,
back before we
here's
go
my,
back to jury.
I wanna make
That
sure
would be
we're
my
clear on this
suggestion.
point.
That's a
Just
good
be
point.
safe.
Let's do that.
Is the meter part of the manufacturing process? It is.
Yes,
Yep.
So it's gonna come up. But the question is, as it pertains to your client, at the end of the day, are there questions going to be asked that might focus on the thrust of the product's liability claim? And it's not just talking about the meter, it's focusing on if there's instructions and or warnings or those types of things that should have been given as it pertains to the meter. Because remember, at the end of the day, there's no claim for design defect and or manufacturing defect, which is different. So
Well-
tangentially, the meter's gonna come up, I think, if it's part of the production process.
Well, that's where I see the problem coming up, because if they ask him, did the meter always work great, and he says yes, then we really gotta get into it, because number one, he wasn't really using the meter after a certain point in time. He just trained people how to use it. Number two, he might
Because he
not.
wasn't in the
He was in
batch room, is that what you call it?
He was in the concentrate room, he wasn't actually the one measuring the mixed product.
Okay. So where do we go from there? Because at the end of the day, that's what it comes down to. The theory.
We don't know, we're all guessing what he's gonna say.
But here's my point though. If he's talking, he's gonna have to discuss the meter and the meter readings on some level, right? That's part of the production process. So how can you ask questions about the production process without saying, okay, what were the meter readings?
You can ask questions when you get to the, did you have problems, did it work well? If you get into that, then they're opening it up, I'm gonna say it's opened up, and now we gotta deal with it. It's gonna be a much
Once
worse
they get
issue.
that, then I get to bring in the lawsuit. That's the problem with this whole thing.
That as well.
It's not easy, but we'll just have to deal with it.
Commissioner, we'll have to get.
That's not how you do it.
I don't know that this lawsuit is relevant to, you know, what was the recipe for real water? That's the question I have for him. In general, the recipe was potassium, magnesium, and a negative work reading of, and that's where I think Mr. Marlowe was having difficulty with his memory. Guy's in his 80s, not a big deal, but, you know, I don't think he got the target reading right when he testified in front of the jury because of his age and inability to recall.
Okay, assuming that's the testimony, does that open the door?
How does a number open the door?
Well, that's what they're saying, they're taking a position. I mean, I understand your query.
I wouldn't have any problems with that, Your Honor. I wouldn't, on behalf of Milwaukee. If the issue is, this is the number we had, okay, Marlowe has a different number, and I don't even care if they want to explain that. That's
That's,
still
yeah,
not
that's
the
what,
meter.
it opens the door to why. Why is there two different numbers? And he can just say, well, John doesn't remember, John Marlowe doesn't remember it right. Okay.
Well, if he goes down that road regarding the meter reading and the like, potentially, that can open up the door to everything.
Or if it helps, we did not intend to address the discrepancy between Mr. Marlowe's 130 and Mr. Jones's 225 during the closing argument. I mean, it is a potential issue, but we didn't intend to go into that.
Well,
So, and he does, just for the benefit of everyone else, in volume 2 of his deposition taken, he also goes through the meter and the instructions again. So it's in both depositions.
Yep, he does.
The,
But there's a play, his deposition for those parts.
Yes.
I don't think this is gonna become an issue, quite frankly.
yeah, I think
So-
it's safer not to, but, you know, I mean, we don't have, it's not within our discretion to control, Real Water's defense, so. But we can mitigate against the risk with the court's admonishments to, Mr. Jones. Then it's all, after that, it's just controlled by Mr. Mr. Odou's, artful question.
all right, well, I've been put on notice regarding it. Mr. Odou, you can give me a list of maybe 2, 3, 4, 5, 6, or whatever the number might be, regarding cautions, right? You can do that. Then we'll review it together, and if everyone's on board, that's what we do.
Your Honor, Mr. Robbins just brought forward to my attention a sentence within admitted exhibit number 1, the MMWR report, where it says that Real Water ceased operations. I think we probably should redact that line. Fortunately, we haven't put it on the screen to actually emphasize that language. We haven't mentioned it, so I think we can redact it so if the jury wants to look at it during deliberations, it's not there. I agree with Mr. Robbins that it should be redacted.
Mr. Robbins, anything you want to add there?
No, that's it, Your Honor.
We'll redact it, just make sure that it's redacted.
So Tori, I guess you could provide it to you?
Yes.
Judge, and Mr. Rasmussen, or Mr. Odou said something that kind of triggered another thought, which is there's no cross-claim between Real Water and Hanna. So what is Mr. Babcock going to talk about? Because Mr. Babcock's meter testing was all thrown out. And so the other part of his opinion was that Real Water had a poor manufacturing facility for this, that, and the other reason. Which, you know, I like that testimony, but I mean, really, where does it fit in at this point?
There's lots of things.
And where liability has been admitted.
The manufacturing process is something that he needs to go over as well.
Okay. And how many times will we go over the manufacturing process?
It'll be the first time the jury's heard someone that's actually a chemist.
Dr. Hudson's a chemist.
I'm sorry, Jared, I couldn't hear you.
Dr. Hudson's a chemist. Got a degree in chemistry.
You're right, but he's not a chemist, he's a doctor. He's a doctor of medicine, isn't that fair enough to say? He does liver transplants, isn't that what he testified to, Teddy?
I just had to
Well,
put it.
I think what gets overlooked as far as these issues are concerned. Yeah, some of these doctors might not be a chemist, but that doesn't mean they're not a chemistry major, right? And just as important too, some of these doctors, like he was a fellow, right? That's what, 10%, 20% of the board certified physicians in this specialty highly qualified. But my bottom line was this, I kind of chuckled during his deposition, he was asking technical questions regarding, what was this, a specter?
Yeah, photography.
Yeah, and of course he knew what it was, because he was,
Yeah, I did have a
right?
question.
Of course, I mean, these guys are, from what I know, anytime you start getting doctors that are double and triple board certified, they're pretty smart. And they know a lot about a lot of biology and chemistry. People forget that's what they had to take in their undergraduate courses, and they follow up on that.
That's right.
And they're really smart. Probably the best way to say it. So it didn't surprise me at all that he knew the answer to that. So circling back again, just want to make sure I'm clear. Regarding the witness's testimony and this dealing with the processes. Because who's the witness again? I just want to make sure I'm clear.
Dr. Babcock,
Dr. Babcock.
he was the one that did the meter test. The meter tests were excluded. I don't think he had any significant opinions about the meter other than testing. So, you know, he's going to describe the processes. I don't want to see that as a backdoor way to get into the meter testing, which is what I'm afraid of.
And once again, I circle back, how is that relevant?
He also has opinions in his report with regard to hydrogen.
Does he say it's safe and effective or something?
Does
like
not.
that? Okay. Then how would that be relevant?
There's a chemist that's going to say that, and he's also going to talk about how it behaves, which has not come into evidence yet.
No.
It dissipates over time.
It degrades.
Okay, degrades, dissipates. I got you. And here's my question, and this is an important question, really and truly. Real Water's admitted to liability, right? Responsibility, so how is that relevant? Especially when you're dealing with a failure to warn product liability.
There's stuff in here that the plaintiffs are now trying to get in with regard to, for instance, fitness for a particular purpose. It's something they've added into their jury instructions. It was already ruled on by this court. I anticipate that this court's somehow going to magically, even though you said nothing more, nothing less, this is all you can say about fitness for a particular purpose and that particular cause of action against Hanna in Milwaukee. Now it's up again. We just saw it in the jury instructions that have been provided, and you'll have to be able to deal with that if this court decides that that cause of action that's not in the complaint is somehow magically now in the complaint. And so did the meter meet the particular purpose? But it's going to be up to you because, and so it's going to be an issue that we're going to have to deal with today anyways. It's not a cause of action. It was never pled that way. We don't, that's a negligence-based cause of action for an implied warranty for a particular purpose. It's not something that but we may have to deal with now because they've got it in the jury instructions. And that has to be done over. Besides that, you know, he's used an ORP meter as a chemist many times, not just in the testing that he did here. How does it work? What does it do? Why does it behave this way? All of those things need to be answered. But we're going to have to deal with that particular issue again. We have the transcript of what this court said, and I'm quoting you exactly. You get to say, this works, it's not a cause of action, nothing more, nothing less. Exactly your quotation. We provided that to the plaintiff's counsel, and he still wanted the jury
I mean,
instructions.
fitness for a particular purpose, didn't that go to a breach of the warranty?
Yes.
Judge, we filed a motion for summary judgment on this that we won. We won the motion for summary judgment. We won that motion. You granted our motion, okay? And you said.
Now, when you say.
No, but you limited that, he limited the language that could be used. Yes, I will concede that you granted that to be able to say fitness for a particular purpose, but they've now got this almost as a cause of action for damages in this case.
Well, not only is it almost a cause of action, it is a cause of action.
There's
And
no,
that
where's
was
the complaint?
This was argued at the time of the motion for summary judgment. Your argument was that it didn't fit within the four squares of the complaint. Our argument was notice pleading. We went through all the notice pleading cases. And we won. We
And you
won.
limited it, the court limited it to 4 words. Nothing more, nothing less. You said that, Your Honor.
I mean, you can show it to me, but my point is, I don't have that type of computer-like recollection on every issue. I do remember the argument of the.
So, an implied warranty of fitness for a particular purpose, you said the following. Okay, what I'm going to do as far as the motion is concerned, it's going to be limited to the request that's specifically set forth on page 11 of the conclusion. And that would be MW500 was being used to take negative ORP readings when making alkaline water, period. Nothing more, nothing less.
That's exactly what we put in our order. So they tried to run away from that in their order. And that's why there's no.
No, that's not what you're arguing.
How can we win a summary judgment saying that it's implied breach of the? The summary judgment was focusing on the particular purpose, okay? And the particular purpose was ruled upon by the court based upon the testimony of Mr. Brown that 1/3 of the customers were using it for negative readings, based upon his testimony that this meter was fit for those meetings and the go-to meter for those meetings, and based upon his testimony that he had, quote, tons, unquote, of tainted water customers. It's obvious that they knew that this was the particular purpose of the meeting.
So
And that's why we filed the motion.
So they filed a motion in a case that you said, this is a warnings case. Remember, this opens up a lot of stuff we can go over right now, Your Honor, but you denied my motion for spoliation of these meters based on the fact that they were not relevant because it's just a warnings case. Now you see I've got to deal with this.
Well, actually, I denied the motion for spoliation for a lot more reasons than just that.
But that's what you said on the record, Your Honor.
Yeah, but I mean, because really and truly, there wasn't spoliation. You're talking about the probes and the fact that they were dry, right? And that wasn't spoliation as far as this case is
100%.
concerned.
That's how spoliation is.
Yeah, no, but you know what, spoliation has to be relevant. Just because something's missing doesn't mean or something that has occurred, that rises to the level of spoliation. It's right there. I mean, Bass Davis talks about it. I even think I put this on the record. The videotape was relevant for what purpose, whether there was an adequate warning or not when the floors were being mined. So it has to be relevant to be spoliated, right?
Yeah, the actual meters in this case, their availability to be tested is not relevant. I understand the court's thoughts on that. We disagree on that, but I've heard the court's.
Well, I mean, there's no manufacturing defect, right? There's no design defect as far as that's concerned. We can all agree on that. Like if there was a manufacturing defect that was being alleged, maybe I can see the relevance of the meters in question, right? Now, if it was a design defect, well, you could get similar meters from the same batch and make that type of determination. I mean, I get that, I understand what it is, but I never did understand the relevance as it relates to spoliation under the facts of this case. And I don't mind saying, I've had a lot of spoliation cases in this department. But go ahead, Mr. Robbins, anything you want to add?
No, I have a copy of the transcript if Your Honor wants to read it.
Okay. I mean, you can read it in open court, I have no problem with that.
There's two competing orders on this, and we submitted, and we think our orders take what the court ruled.
Have I signed any order yet?
No, there's pending, is that, well, unless you did this morning, Your Honor. There's
No, I
an action item that they were-
We have a competing order because it's just,
Yeah, basically,
there is no cause of action.
They're trying to re-argue the whole issue on the cause of action. That's what they're trying to do.
Would you like to look at it, Your Honor?
No, absolutely.
May I approach?
Yeah, you may. I'll look at that before I sign the order. How's that?
Judge, I think we've submitted the entire transcript of the arguments and everything with our
I
order.
think it's still in the process of being
Or
submitted.
it's in the process of being submitted.
Thank you, Stan. Is this a copy I can keep, sir? You wanna, ma'am, I wanna make it easier for you. And so for the record, what page was that again, sir?
The last letter, the next to last page is the.
There's a yellow mark.
It's page 144.
In addition, I would like to note that I think we need,
Let him read it.
okay. No, just the transcript.
All right. But ma'am, did you have something else you want to add? I'm sorry.
I just think we all need clarity as to plaintiffs think there are 3 causes of action alleged in the complaint. We think there are 2, and we don't know what Your Honor thinks. So if you think there are 3 causes of action, then before we finish this trial, we should know that. If you do think there are 3 causes of action, we should also know the language that you're looking at in the complaint that makes you think that this 3rd cause of action was there. Finally, I think we never argued privity, horizontal and vertical. I asked for a supplemental briefing on that, and there wasn't much discussion of it. So if there is a third cause of action, I have some thoughts on privity, horizontal and vertical.
Thank you.
Judge, first of all, we argued this. This was the central argument that they made, that it wasn't raised in the complaint. We argued this at the motion for summary judgment hearing. So to come up and say, oh gee, there's no third cause of action, that ignores everything that was done at the summary judgment hearing. That's already been ruled upon. Now, with regard to horizontal and vertical privity, that was addressed in our summary judgment motions. I had a specific section on that. Maybe they didn't address it, but I addressed it in the summary judgment motion. So that issue has been addressed also, Your Honor. And to suggest that, and now we've got to go back to the complaint and try to tease out the cause of actions. When we filed a motion for summary judgment to preclude this kind of last minute attempt to constrict plaintiff's case. So in the verdict form, you will see that we have two causes of action against the meter peoples. One, failure to warn. Two, breach of implied warranty of fitness for a particular purpose of making alkaline water. Those are there. That's it. Two. All right. And that's what we've got in the verdict form. That's what we have in the jury instructions. So this, oh, we don't know what's going on, Your Honor. I mean, all they have to do is read the transcript of the summary judgment, or even the motion. The motion sets this forth in exceeding clarity what the cause of action are. So, Your Honor, I really object to this last minute attempt to re-argue the motion for summary judgment has been lost.
I object to the last minute removal of a document I really wanted in the case, so sometimes things happen.
Well said.
I understand that, Mr. Robbins. Thank you, Your Honor.
Are we done with that issue? Because we,
Yeah.
We didn't really address the background.
that's exactly what I was gonna say.
Which issue is that?
So, Your Honor, Dr. Babcock has a bunch of criticisms of real water employees in his report. They're no longer relevant. We've admitted liability, we've accepted responsibility. That's where we started when we went off on this tangent on the summary judgment issue. And Real Water renews its objection to Dr. Babcock's testimony as to those irrelevant issues.
Okay.
There's been no motion to prevent Dr. Babcock from participating in time trial.
All right, I understand that. But that doesn't, just because you didn't follow motion, and I think I've discussed this, that's why I prefer motions in limine. And I think whatever the EDCR is, that says you have to meet and confer, continuing the motions in limine, I think it's somewhat of a waste of time. And the reason why I say that is this, I would understand, I have not practiced under that rule. It was different, you just file your motions in limine. But other than just general evidentiary issues like liability insurance, I would dare say there's probably not much agreement. And that's a complete waste of time. And just as important too, you don't know what the call of the question is until you read the motion anyway, right? So, and here's my point, just because you don't file motions in limine doesn't mean you can't object, right? So I guess what we're doing now is objecting. Is that correct, Mr. Odou?
Yes, Your Honor. We figure it's fair to get our objection out now because presumably he's going to travel to be here, and if they want to re-argue this at the time he starts to testify about real water employees, and we'll renew our objection. But it seems fair to raise it now.
Dr. Babcock did both a preliminary report and a rebuttal report. He has several different opinions. Not all of them are against real water. So much had to do with the Dr. Machine as well. There's been no motion to not allow him to talk at the time of, or testify at the time of the trial in this matter. I appreciate this is kind of a veiled way of trying to get him out now, but if they really thought that there was no value, and I understand, Your Honor, I also understand that, remember, up until, 2 days before we get to trial, right? And motions may have been heard. That is when we find out for the first time, and I'm not criticizing Mr. Odou. That's when we find out for the first time what? We accept liability. Now, you might say, well, then at that time, Dr. Babcock becomes irrelevant. Well, no, he doesn't, because there's lots of things that we need to be able to do with regard to his take on how things are done in the manufacturing process that has to do with this ORP meter and what it has to do with hydrazine. Hydrazine is absolutely a very important, and he worked with it, it's in his CV. For years, he worked with hydrazine. He worked in the jet fuel industry. We found a guy that did that.
But here's my, I mean, I get that, and he might be an expert in hydrogen, but my question is really this fundamental. In light of the fact that the defense, and I understand it was done at the very end of the case, admitted to liability as it pertains to, quote, production of hydrazine being a defective product. I mean, real water being a defective product. Yeah, what's next?
Oh, lots of stuff. But that's the time, that's when we get to talk about his report and what hydrazine does and how it behaves. I've already said that. Dr. Najim already talked about it and how it behaves. He talked about hydrazine and how it behaves. We get to counter that.
Okay.
That's in evidence. It was told to the jury, hydrazine would have an oily sheen, I believe is the words that he used. We get to talk about that.
All right, Sir, Mr. Pepperman.
From the plaintiff's perspective, the primary concern with Dr. Babcock is the reference to him talking about the ORP meter. He testified that he's used an ORP meter in various times to take positive readings. He's never used a Milwaukee 500 ORP meter, and he's never used any ORP meter to take negative readings. He did testing. All of his opinions about the meter were all based on his testing, which is what we excluded. His testing and his opinions that were based on the testing. So this suggestion now that he intends to call him because he has lots of things to say about the meter, that I think is cause for concern, because we don't see how any of the meter stuff has not been excluded, is relevant, and in light of the admission, how much of any of his testimony is relevant. So I just would make sure we're clear on the record that his meter testimony was squarely excluded, and any intent to have him give opinions on the meter should not be allowed.
Here's my next question. Has he offered any opinions that would be permissible for humans, mammals to ingest hydrazine?
He's a chemist, he wouldn't be in that area at all now.
Okay. And so he's not going to testify in that specific point, because medical causation is not an issue. What would he testify to outside of that?
It'd be nice to go over his opinions, and I'll just read them to you. ORP is a measure of the ability of a solution to donate or accept electrons, like measuring temperature with a thermometer. An ORP measurement taken with a probe does not alter the substance being tested, nor does it add or take away anything from the substance. Number two, real water use ORP is the primary determining factor of whether the proper amount of mineral concentrate was added to the product. We'll talk about that. Number three, a lack of basic analytical knowledge was exemplified in testimony by real water employee Casey Aiken and Blaine Jones. Number four, lack of apparent knowledge by, and that's when we get into, if you don't have that basic analytical knowledge about hydrazine, you don't know whether or not, when you're measuring, you have any idea whether those measurements are valid or usable or not. And whether or not the assumptions that both the plaintiffs are still making and real water was making are even valid. Because as a chemist, you can say, these aren't even valid. You can't even do this kind of sampling this way. This was always going to be invalid. We'll talk about it.
Okay.
There's a-
Okay, it seems to me that what he's doing is he's pointing the fingers at real water. Say their testing protocol and procedures were inappropriate and unreliable. That's what it sounds like to me he's saying. But I circle back to,
So
based upon the current status of the case, how is that relevant?
it's relevant because the plaintiffs are saying that because of a negative work reading by Casey Aiken in September, October of 2020, that Casey Aiken added more concentrate. And that was that particular purpose, I guess now, which is a new cause of action, he did so. And that there was no warnings, I guess, that he could have relied on Mr. Aiken to not do so. And that the sampling that was done by Mr. Aiken was invalid to begin with. We'll get into that. But you're asking me now to put my case on.
No, I'm trying to understand, I'm not asking to put your case on. I'm just trying to understand where the case is currently, because we can all agree one thing that's occurred that's really changed the way this case would be defended. And Real Water admitted liability, right? And so a lot of the issues that you're referring to me, appear to be facts and or opinions that would supplement the defense position regarding liability in this case. Liability has been addressed by a stipulation. So after Real Water admits that they're responsible for the injuries in this case, what's next from your perspective? And the reason why I say that is this, what does it have to do with the allegations of a defective product? That's all I'm asking.
It has nothing to do with the defective product. It has to do with, here's what, the affirmative defense misuse is still available for us to go after, right?
Well, I mean, here's the thing about misuse. And you say that's something that you can always address, but is there any evidence of misuse by the plaintiffs?
Thank you.
I understand products liability. That's
There
really.
is no by the plaintiffs, there is,
Okay.
but by this defendant, there was misuse, okay?
But I don't think that's,
But what they're claiming is that the instrument caused the plaintiff's injury because somehow it was an inaccurate reading sometime in September, October of 2020. Because it read low. There's a reason why it read low.
Where's the misuse, Your Honor? I mean, they were using it to make alkaline water, which is the intended purpose of the meter.
The intent of it was actually electrical. The pH was there to actually do alkalinity.
but there's,
Which
once
he'll go
again,
over.
I circle back to, when you talk about product misuse, you're talking about the end user. And hypothetically, I mean, I would think bottled water you could use for almost anything, right? But how were the plaintiffs in this case, how are they involved in product misuse on any level?
They're not. I've said that. The products are not. This was all done by Real Water. I agree with you. It's what the plaintiff's counsel is suggesting through all of these Real Water employees who have already admitted liability that when they're using it, they came up with numbers, and those numbers had to have been inaccurate, which means that the meter was bad. No, there's a plausible reason, very much so, that every one of the readings by the meters were always accurate, and that's what we're going to talk about.
There's misuse focuses on how the Real Water employees were using it. They were using it to measure negative ore on alkaline water. That is an intended use of the meter. That can't be misused by definition.
I mean, I understand that. That would be like, classic product misuse would be a ladder where someone steps on the very top of the ladder. That's where you see product misuse, because that was never the intended purpose for a ladder, to stand on the top of the ladder and fall. And there's other examples, of course, but
But he has, I mean, it sounds like you just want to not have him speaking. He has 9 different opinions just in his first report, and then we have a rebuttal report that discusses things, all of which are discussed in his report. It's not been hidden. I see this now as an attempt now, which, you know, you want me to go ahead and try to defend Dr. Babcock, what he wants to do, when there's no motion pending to say we want him to never be able to testify. That's not before this court. No motion was filed on that with regard to that. Remember, the warning right on the side of the box says safe laboratory practices. It says it right there in our warnings. He is also going to be able to testify, and it is in his report. What does safe laboratory practices mean to him, since he's in a laboratory almost every day?
Here's my question, and we just go to Nevada Pattern Jury Instruction 7.07. And so, under the facts of this case, if you were tendering this jury instruction on product misuse, and you read it, it says, quote, misuse of a product means a use which the defendants could not reasonably foresee, period. Example, you got a step ladder. You don't stand on the top of the step ladder, right? And that's a classic product misuse. There's a lot of different product misuse applications. And it goes on, it says, the mere fact that the defendant may not intend the product to be used in a certain way does not mean that using it in that way is a legal misuse of the product. If the defendant should reasonably foresee that the product may be used in a way other than intended by him, such other use is not misuse. And that's the jury instruction. And my point is this: say whether they were doing it correctly or not, they were using it to measure pH and water, right?
Negative or.
Yeah, I understand, but positive, negative, I get that.
Right.
But it was being used to measure pH and water, right?
No.
No.
Well, negative versus positive.
Oxygen
Not
reduction
pH.
Not
potential.
pH.
Yeah.
Oxygen reduction potential.
Okay, whatever it is.
Or,
But my bottom line is this: if you would have used that ort meter to help charge a battery, to jump somebody's battery, and something happened, and it exploded, and that person, because it has a cord, it has two things coming out, and you try to use that to jump a battery, clearly your client wouldn't be on the hook for that, because that's not a foreseeable or intended use of an ort meter.
Your Honor, and to piggyback on what you just said, I just read Mr. Babcock's all 9 of his opinions. The word misuse is not included in any of those opinions. So I'm not sure what Mr. Rasmussen is talking about, but I'm reading it right here, and I don't see the words misuse in any one of the 9 opinions. So I don't know what opinion he's speaking of, and I don't think the court's asking him to lay out his direct examination, Mr. Babcock, but certainly to answer the court's question directly, the word misuse is not in these 9 opinions.
I'm just going to say that I appreciate the court's thinking on this. I appreciate that what you're asking for. I don't believe we did this with any of the plaintiff's experts in any way before they were able to testify. I understand that we just want to go after any one of the experts that we have, and I appreciate that. But I'm going to make my record that none of this was done beforehand. You had motions eliminated to go over this. You decided to take out his testing because you didn't think it was relevant, because it was not, it had to duplicate the exact same water that was negative 225 or negative 550 that was originally created in a concentrate. And since it wasn't the same water, under Hallmark, which is, the law is substantially similar, the court said, no, it needs to duplicate. I know you didn't have the titanium tubes from Russia, but we're going to get rid of the testing anyways. Okay, got it. We understand the ruling. Now we're going to the next step somehow in this hearing, in which nothing is in front of the court to say Dr. Babcock can't testify. But since it's now been brought open, I'm going to have to try to defend having Dr. Babcock be able to testify when there was no motion pending before this court. They can certainly object, as has been objected every time I stand up, to any question that I ask any witness. They can certainly get up there and try to do that. And the court will sidebar and we'll deal with it then. But there's no reason where we're talking about jury instructions on what to do with this thing. The biggest issue really is that there is no cause of action, which is where this started at, for implied warranty of breach of particular purpose in their complaint. They have 2 causes of action which they specifically identify. One is failure to warrant strict product liability, and the other one is strict product liability because it's an unreasonably dangerous meter. That's their 2 causes of action. Then the strict product liability does not envelop particular purpose. It isn't in the language of that particular one, and that's what we were discussing. Now we've somehow segmented and snippeted it down to, well, Dr. Babcock, what does he say in his report? There are 9 different causes, 9 different opinions just in one report. He intends to talk about his conclusions, just like Mr. Motley did, just like Dr. Hutton did, or I should say Dr. Motley as well. I'm sorry, I keep making that mistake. But that's all he's going to do. I don't know why we're discussing this right now, but I certainly don't want to have his, today this court rules, oh no, we're gonna dismiss Dr. Babcock because all he could ever talk about is real water. That's not true. Understanding what an ORC meter is, all its different purposes and portions, how it works, is certainly, I think, not been discussed with this jury yet. What does a platinum probe do? Why is it platinum? What is the other parts of that? What do they do? How could this be in trouble or could be needing to be, the probe needs to be replaced? What's the difference between a meter? What does the meter do? All those things are there. He's used it. He has experience with it. And it's in his first conclusion. Those are things that we can bring up to bolster what the plaintiffs have already put on and says, these meters are all bad. We get to say, no, these meters are all good. Basic, right there.
Actually, I think the case is much different than that.
Okay, I'm sorry, Your Honor, I apologize.
No, I mean,
Don't waste your time.
No, you're not wasting my time. I mean, I can see potentially the merit to how an ORC meter works. But remember this, they're not alleging product defect vis-a-vis manufacturing and or design. What they're alleging is essentially this, it's a failure to warn products liability case. It's the failure to give adequate instructions as part of the instruction manual. That's what they're saying as it relates to ORC meter readings, right?
Right.
And how you condition, isn't that the word they use, condition?
Condition,
The
yes.
platinum probes, right?
Right.
And there's a
All
way
this.
you're supposed to condition them. They had the conditioning kit that was later recalled, I guess is the best way to say it.
And then they went to vinegar, and we have vinegar at the place, and he's gonna say that would be adequate condition, all of these, and since we know they were storing them in vinegar, everything was conditioned, and how long it takes to condition with vinegar.
Your Honor, that's the testing that was excluded. He's telling you that there's been no motion pending. There was a motion. We filed a motion to limit Dr. Babcock's testing and opinions
His
based on the
testing is
testing.
different than saying, were they stored in vinegar? That's two different
No,
things.
it is not.
How the hell is it not? Oh, I'm done, I gotta go take a break, Your Honor, can we?
You can take a break.
Thank you. When you're gonna lie like this, my goodness.
No, I don't appreciate being called a liar.
And that's why I need to take a break.
Take a break, Mr. Rasmussen.
Off record, Judge.
We're off break. All right. Okay, we're back on the break. Product liability.
All right.
Yeah, here's my, as far as the summary judgment motion is concerned, what was the motion number? Anybody know?
I think it was 6, you know, it was either 1 or 6.
No, but I mean, as far as the, remember we assigned numbers for them?
Plaintiff's motion for summary judgment number 6. Oh, the docket number?
Docket number.
It's 307, Your Honor.
Thank you. I need,
That's my best guess.
so it's docket number 307?
That's my guess, looking at the minute order.
Yes, it is 307.
Okay, I'll pull that. Let me see here. Okay, so moving on, where are we?
Jury instructions?
Yeah. Have we agreed to any, Mr. Pepperman?
Yes, Your Honor. I think most of them are either agreed to or close. There's some modifications, different forms that we have. And then there are probably about 10 to 12 that are in addition to those that what my suggestion would be is that we go through the ones that are either undisputed or just need to work on the form of them first to get at least most of them lined up. And then we can start going through the ones that I think there may be some disputes on.
All right. You know, in total for real water, we agree. I think it probably makes sense to start with plaintiffs, and then we have some additional ones that I don't think are controversial. And then we will eventually get into the ones that are more in dispute. It probably makes sense to just plow through them and see if we have an agreement.
I have a copy of plaintiff's proposed jury instructions.
Do we have a copy of the defense proposed jury instructions?
We have a copy of Hanna for the court. I agree that there's gonna be a lot that we're all gonna agree to, and there's probably gonna be a few that we're not. I thought we were gonna do that today, just go over and say, is this one in or out? Go by stipulation.
Or a rule? That's what we-
Exactly.
I have real waters, but like I said, I think just about all of ours, for about 3 are in plaintiffs, and I can identify those 3 when we get to them.
There's a couple of additions proposed by Hanna that aren't in plaintiffs, that are just stock, that we didn't include them because we didn't think they were really necessary, but I don't think there's really any meaningful objection to them. They're just stock instructions.
Yeah, I think we will have.
So Your Honor, what I would suggest is that you use ours because it's the most comprehensive, and then go through it. And as we get to one where there's an additional one from either Real Water or Hanna, we could let you know, and you can look at it and you can add it to the stack.
That's what we were suggesting.
We agree, except what the concern is that if they've modified any of the 1986 rules, we use specific language that was in the 1986 rule, and that alone, we did not modify any of the instructions. Unless it was the name of like the party. For instance, the plaintiffs now, plaintiffs now in plural, or,
I understand.
yeah, things like that.
Mr. Robbins?
I agree with Mr. Pepperman's suggestion on how to proceed here.
All right, Mr. Pepperman, give me your list. Give me your instructions.
You have an extra copy?
I have this one.
Do you have another one?
This is the only one that we were given.
I gave my copy to
yours.
Oh, do you want one more copy here? Yes. Give it to the plaintiffs. Plaintiffs have got a copy of ours.
How quickly can you make copies? Just to make a copy, extra copy. This is as a follow-up, did we come to some sort of consensus about, what was the name of the expert? Was it Babcock?
Babcock, Dr. Babcock.
Yes. And if we didn't, this is how we handle it. We'll just handle it like any traditional trial. And that's kind of why you try to work things out. If you can't, just object. And that's what we'll do.
Thank you.
Hey, John.
Let's see, 1986. Okay, so I'm looking at plaintiff's proposed jury instructions.
So the first one is page 2, which is the pattern jury instruction 1.00. I think we agree on that one.
I agree.
Agree.
Page 3 is jury instruction 1.01, use of instructions.
We agree.
We agree.
And Your Honor, these will all be from the 1986 edition unless otherwise noted. Page 4 is jury instruction 1.02, which is the masculine form of pronoun.
We agree.
Agree.
Page 5 is jury instruction 1.03, which is what is and is not evidence.
We agree.
Agree.
Page 6 is jurors forbidden from making any independent investigation, jury instruction 1.04.
We agree.
Agree.
You agree too, Mr. Robbins?
I agree to all unless you hear me jump up and
Okay.
say
Didn't
something.
overlook you though.
You're not overlooking me, Your Honor.
Page 7 is jury instruction 1.05. Jurors must use everyday common sense.
We agree.
Agree.
Page 8 is jury instruction 1.06, corporations as parties.
We agree.
Agree.
So the next one is the jury instruction 1.07. It's the collateral source one that's proposed by Hanna. We didn't include that one in ours just because we just thought why reference insurance at all, but Hanna has it proposed.
Yeah, real water would suggest excluding 1.07.